Real good. A pleasure to be here, and it really like to start by acknowledging the importance of what the Center for Practice Transformation does in providing these things. It's a unique service, and as a presenter, it's a wonderful feeling that you can reach that many people all at once. So again, really appreciate the opportunity to do this, but also appreciate the existence of this whole program and the ongoing programs they provide. Usually before I do a presentation, I check the newspaper. It's mostly in the States, some pretty bad news these days. So I went looking to find something of interest. And one item I found that was interesting was a story, apparently a ship went down and three people ended up on a lifeboat together. And this is a story being told by one of them. They were heading towards an island, I guess about a mile off that they could see. And in the boat was a social worker and a priest and an attorney. And they decided, unfortunately, that the boat was taking on water. It wasn't going to get all three of them to the island, but maybe if one person swam, it would make it. So they all agreed to that, decided to compare their swimming skills, and it turned out they all were about the same level, which wasn't real good. And so the lawyer said, look, we just got to draw straws. So they drew straws. The lawyer got the short straw. She started stripping down, preparing for this long swim. And suddenly the priest looked over and noticed there were dorsal fins. There were sharks all around this little life raft. And the lawyer kind of gulped and said, I guess better one than three. And she dove in and began swimming. And the sharks pulled back and they formed a corridor right to the land. And the priest said, heaven be praised, God's intervened. It's a miracle. And the social worker said, miracle, my eye, that's professional courtesy. One of the challenges in dealing with ethical and boundary issues is it's very easy to be distracted by worrying about legal things. And I want to try to focus away from those things today because that's not the most important thing that we need to pay attention to. Okay, Walk-in Counseling Center, where I work and from which I'm presenting, is a small nonprofit founded in Minnesota in 1969 by professionals volunteering their time. Through today, we have about 170 professionals and advanced graduate students who volunteer their time to provide free, no red tape counseling. But given the situation, which we'll be talking about today, we're not seeing people physically on a walk-in basis. They're calling in or Zooming in, and our teams meet on Zoom. At the end of each clinic period, the teams meet and discuss cases. That's one of the advantages of volunteering there. We also provide consultation and training to the community. And we have a history of taking on ethical and practice challenges, both in helping consumers with complaints, but also assisting professionals. In recent years, probably the two most common activities have been workshops and training programs, which are most typically provided by myself. And then the other thing is we do evaluations of people in trouble with employers or with the licensing boards. And we do remedial boundaries coaching. We evaluate offending professionals and so forth. So we're still actively involved in all of that kind of work. And the center continues, as it always has, to provide services to both the community at large and to the professional community. Now, the standards for conduct, when we're talking about boundaries and ethics, the first thing you got to think about is organizational rules and policies. Wherever you work, those policies and rules are the most important guideposts. And I can't tell you how many times someone calls me for advice or information, and it turns out that they haven't looked at their own policies. And that's a real key thing. Then you have professional ethics codes, NASW, or any professional organization. For those of you who are in several professions, say marriage and family therapy plus social work, or psychology and social work, you may have two codes that don't match on every area and two different places you could look. But then we have licensure related codes of conduct. In Canada, you have various professional colleges where you have the very same thing, where you have some conduct rules that are part of your regulatory process. Then you have general rules and laws, many of them dealing with payment for services or access to information. And these often overlap and sometimes conflict with each other. If you're in a substance abuse program in the United States, regardless of your profession, if you're providing services there, you're under Code of Federal Regulations 42, which is quite different in some areas from other kinds of rules. And then we have HIPAA, which says that HIPAA doesn't rule the roost. It only rules the roost if your existing state rules and laws don't provide better protection or control of information by the client. So even here, the laws don't even match up in many areas. But the key bottom line that you need to be focused on and thinking about is standard of care, what a reasonable and prudent practitioner would do in the same or similar circumstances. That can only be established by expert testimony. That's not from a law or a rule or an ethics code. I might add that the failure to meet the standard of care is what we call malpractice. So when you hear about a malpractice suit, the first stage is you have to have a credible expert who can articulate that there was a standard of care that applied and that it wasn't met. Then the rest of the case is about any damages. Now, before going on to some general comments, let me just note that for those of you in the United States, we are currently practicing in a situation which has gotten especially rough in the last couple of days. The level of worry, fear, disillusionment in the community is quite palpable. And whether I'm talking to the staff of an organization or agency, or some of my colleagues or clients, there's no question that a real pall has been cast over an awful lot of things in life. And it's also very distracting because, and I only remember this in Watergate in the mid-70s, where we had trouble getting to work because we were always watching the TV to get updates. So we're in a situation that's gotten quite different from the time when I created these slides a couple of days ago. Now, practical challenges in maintaining boundaries and practicing ethically are that our central duty is to engage the client. If you don't engage the client, you can forget the rest. To establish a trusting relationship, but we're supposed to get informed consent. And increasingly, we're being asked to check more things before we get started. The only problem is the longer the forms are and the more legalistic they are, the more they get in the way of establishing a trusting relationship. So we have a built-in conflict right off the bat in almost any relationship. The multiplication of forms and questions and stuff on these to get started has increased dramatically during my more than 50-year career. It's there used to be you sat down with someone, said hi, and you got going. Now there's a whole lot that happens beforehand. We're also building dependency, whether you're in financial services or whether you're in housing or whether you're in direct clinical work, in your mental health, whatever. We're building dependency with the goal of building greater independence. Now, those two are always in conflict. The more dependency you build, the more difficulty or challenge you have in helping someone then become independent, not only of you, but of past dependencies. And in the United States, the healthcare marketplace governs a lot of what happens. We're, I'm sure you all know, we're the only developed nation that does not have a health plan and a health system. We have a marketplace which causes all kinds of impacts on service delivery. Last but not least, dealing with economics and societal pressures is always a part of any kind of professional work, and it gets impacted by our professional duties versus some of the realities of life for our clients. Now, in our current context, some things that have changed and things that are challenging. With the pandemic, pretty much no matter where you are in the world, the likelihood is that services are remote rather than face-to-face, with the exception of some substance abuse related services. I know in Minnesota, for example, virtually everything is being done remotely. And the question remains is, when will face-to-face be possible? And once it is, if there's an option, how to decide which service to provide. The client may want one thing, you may feel comfortable with another. There's a balancing act here. And the other question is going to be whether or not there's a difference in terms of outcomes or what you think can be done remotely versus face-to-face. Certain clients you may feel really need to be seen face-to-face. Others not only may not need to be seen face-to-face, but may prefer telehealth or distance services. We are also facing economic insecurity. A major recession is underway in the United States and in most parts of the world. So all of a sudden we have financial pressures that are broader and deeper, and some of which don't have an easy end in sight. There are tons of pandemic-related ethical challenges, of which we're going to deal with some, but some of them have to do with the issue of differences between family members as to safety, differences on a vaccine and whether you trust it, that may not be the same for everybody in the household. We also have people thrust together, living together more frequently, and we have people who are not getting out of the house. We know that family violence is on the increase. There's a variety of things that are on the increase at this point. And last but not least, the impact of Black Lives Movement in the United States and or other such movements elsewhere has led to more distrust of the police, certainly in certain communities. And that has complicated the situation where you're using the police for a wellness check or something. That may not be quite as simple in some circumstances. That's really changed. Oh, so somebody asked about the punchline of the shark joke, and the punchline was that the priest had said, "Heaven be praised," and the social worker said that's professional courtesy, that the sharks have pulled back to allow their fellow shark to swim to shore. That's the punchline. Now, the ethical framework I use focuses on 5 factors, and these factors may play a role in any given case, and looking at each factor may not give you the same answer to an ethical dilemma. First of all, beneficence. Obviously, anything we choose to do should have a potential to help, and the option that is believed to be the best help, or which will help the most, gets points. The other thing is we want to avoid or limit harm. Anything you do that can help can hurt. It's not just medications that have side effects. Having someone talk about past traumas, having someone spend time focusing on them, in fact, has risks associated. People put things out of their mind for good reason. So avoiding or limiting harm is always key. So we want to help maximally. We want to do our best to avoid harm or limit harm. Then autonomy, the client's input and role in decision-making. That does not appear in any ethics code prior to World War II. Fundamentally, the only viewpoint that was considered important prior to that was the judgment of the professional. The client came into being because of, as you might imagine, the Nazi doctors was a big part of it. But what you may not know, in the second trial of Nazi doctors, the Nazi doctors were acquitted because the defense they used is, you're doing some of the same stuff as we were, and you're in fact doing all kinds of things without people's consent. Supposedly, experimentation on American service personnel has stopped, but doing that without their knowledge or permission was a long-standing practice to try out all sorts of things. Fourth principle, or fidelity, is to what degree is it consistent with what was promised or what your role is. Here's a classic example of how fidelity, though, does not rule the roost. Good upper Midwest ethical dilemma. You're seeing a client at 4 o'clock one day. You end the session and you find out that a blizzard has started. And in fact, both you and the client are pretty worried about getting home safely. And neither of you has a heavy coat on because the blizzard was not expected. It was supposed to be a dusting of snow. There is an agency rule, by the way, about not transporting clients. You get into your car, you start driving, and you get to an intersection, and there at a bus stop is your client shivering, waiting for a bus that may not come as the snow gets worse and worse. Fidelity says you're not supposed to give them a lift. That's the rules of the agency. That's not within your role. You going to give them a lift or not? Well, there are obviously other reasons that you might choose to ignore what the rules are at that point. Last but not least, justice, the welfare of the client versus others. This is the one place where other people come into play and their welfare. Now, the reporting of child abuse, abuse of a neglected adult, those are all examples of times where you, whether or not your client wants you to, you may have to breach confidentiality, at least to do some reporting. It also has to do with the duty to warn or protect, which we'll talk about later, where you're preventing violence to a third party. And again, where you take that sacred promise of confidentiality, or which the client expects you to hold on to, and you have to break it. The last piece of that, though, is having a basis to proportion services. And that means that there's a reasonable and fair way in which you decide who gets services and who doesn't, that you apply these things in a reasonable and thoughtful basis. And I would just give as an example of a challenge of this thing was something I learned as an intern at a major medical center, where we learned that we were giving a brief intelligence test called the Shipley-Hartford, that was among the things that doctors were consulting to decide whether or not somebody got kidney dialysis. In the 1960s, there were not enough machines, and that meant some people died who would live if they could gain access. Now, obviously, we already have this kind of thing occurring in some areas of the United States where, in fact, they are triaging that way. But the question is, what's the basis to decide who lives and dies? We were appalled that a 10-minute intelligence test was playing a role. Did they have any evidence that higher measures on the Shipley-Hartford meant anything that had to do with health or safety or future? And they had to acknowledge that there was no connection, but it seemed to them reasonable to keep the smarter people alive. Well, all I could think of is, if any member of my family starts having kidney symptoms, I'm going to sit up with them at night and I'm going to violate a code of ethics. I'm going to show them the Shipley-Hartford and make sure they know all the items. But that's a good example of where justice comes into play. If you have a developing country, you may have great difficulty in accessing service, or if you have a country like the United States under siege of the pandemic, this is already occurring as an issue. Now, ethical decision-making is not about what's ethical or unethical, but it's the comparison of the options you have and the likely consequence of each option. So first you have to identify what the options are. Sometimes it's just to do or not do something. That may be the only options, but consultation with others, I have found, is often a shocker, because when I call a colleague for input, I'm saying, I'm trying to decide between option A and option B, and they say, why would you even consider either of those? And they give me option C, which I never thought of, which is better than the two I'm comparing. You then analyze the options based on how various ethical principles are carried out by doing each. You do need to remember to document that consultation was gotten, fairly important in any decision-making. Document, you don't have to document what you learned, but you should document the fact that you got consultation. Now, In terms of a decision chart for options, let's take a case of reporting neglect or abuse in the home. There are neglect or abuse reporting requirements pretty much everywhere in the world, and breaking confidentiality is allowed and/or required. The issue is not whether you're going to do that. Let's say you've already decided it's a reporting situation. What nobody's rules or laws tell you is how to do it. For example, among the options would be, you're going to report a mother. Do you tell her before you do it? Do you report with her on the phone? Do you tell the mother after you did it? Or do you not say anything or explain only if something comes of it? And as you can see, there are quite a few options actually as to how you do it. And the issues which may be relevant could be whether this option impacts on the trust in your relationship, remembering that the safety of the child probably depends more on your working relationship than what child protection is going to do. Safety of the child, danger in the given circumstance, the threatening a child to be quiet, environment, tipping off a crack house or a dangerous household where criminal activity is occurring, fleeing the state or the province with the child, and how would it impact on parent collaboration with child protective services? These are all elements in thinking through how you do the report. So even where there's a legal duty, how you do it is rarely spelled out. Now, in our current context, with regard to remote services, servicing people on the phone, on video, on something, a platform like Zoom, one issue, of course, is what are competences or skills necessary to do this well? That's not been well defined in any profession. And I think the reality is we need to be paying some attention to that. Are there ways to do it better? Now, in the 60s and 70s, we did a lot of training of phone counselors as hotlines developed. Again, there got to be some issues or things to learn. Now, what's the difference between the phone versus a picture situation? Well, one of the first things is a digital divide in terms of equipment. At Walk-In Counseling Center, we'd love them all to come on in Zoom, but the reality is that people are coming on just on phone calls. Our volunteers are there in Zoom and they consult with each other, and the teams meet on Zoom, but we're mainly getting phone calls without a picture, without a visual interaction. And what's the impact of a phone call versus being able to see the person? Well, there are lots of things you can see and understand in seeing someone's face, but there are many people that feel safer without. There are other people that have articulated to us they feel safer if they can see the counselor. So again, whole new set of question marks and things we need to be paying attention to. Now, obtaining releases and sending records has gotten much more complicated when you may not be physically at a center or a site. Mail may be forwarded, and certainly the turnaround time on some of these things is much longer and more complex. And again, the issue as to whether you send something in an email or a fax may in fact now have a whole different set of weights for each of the options, because again, the practical reality has to do with the speed with which the records are needed, as well as their size. Now, what about privacy from the client's end? Who's in the room or nearby? Does a client actually have a private place to talk? Again, in the upper Midwest, we got the problem that in the winter, going out to your car is a tricky business, but that's the most private place in many people's homes, except for the bathroom. So, and again, many people can't occupy the bathroom for an hour-long meeting with a counselor. But again, privacy is very different. Now, I will tell you that it's interesting that professionals who consult with me in groups are telling us that it's much more interesting to encounter each other in their home environments. And actually, some of them feel they're getting to know each other better than they did when they were sitting in the same room face to face, which is an interesting note. But the other issue is what's behind you as you present. I rushed around and did a little cleanup of the area behind me, but I didn't do as good a job as I wish I had before the session. You got to be kind of mindful of what's around. Then there are challenges of transportation. Remote services have an advantage as they can be conducted without someone having to drive through a snowstorm or have a vehicle that works or have the time to do the transportation. One of the things, however, that's come with remote services is, I think, the risk of excessive texting and excessive internet interaction in a written form has risen quite a bit. And I would just end that note by noting that the most common thing I see in complaints against professionals is a whole pile of texts. In fact, when lawyers call me and say, what does it cost to get you involved? I say, how many texts and how many emails? They said, we haven't told you what the case is about yet. I said, I was still asking the question. You asked the money question. I'm going to have to read all those damn things. How do you have a box? You want to give me the dimensions of the box? But I think that that's a reality. And we'll get back to that a little bit later in terms of the remote service situation, our current context. Now, what about services to clients out of state, province, and country? More easily happened if you work for a college or university or counseling center. Many of your students have not come back to campus. They may be participating from somewhere else, maybe outside your country, it may be outside your province or state, or it could simply be in a different part of your jurisdiction. Right now, there is more discussion than ever on extraterritoriality, and that is what happens when you're delivering services at a distance and what's legitimate, what isn't. And can we make it easier for a licensed person who's licensed in one state deliver service to somebody's out of state, even on a vacation or a brief trip out of state? Now, in Minnesota, on April 6th of this past year, an executive order was issued by the governor of the state that out-of-state mental health providers can provide telehealth in Minnesota during the pandemic, but they must register. So they're supposed to, a social worker is supposed to contact the Board of Social Work and just tell them that they're doing it. But at the present time, under the emergency order at least, until further notice, it's been legitimized that, you know, if you're in Alabama, you could be serving someone in Minnesota. You just need to tell the Minnesota board you're doing it. But I think longer term, there's going to be more provision for this to happen. The reality, it is rare that it is not better to continue service on the phone or by Zoom than to ask the person to find a new service provider, especially if it's for a vacation or a break from school. Now, other states, other countries may have rules, temporary or permanent. And again, more and more people are finding themselves needing to check on what the rules are. There's always been a question, though, of where the service actually is taking place. Is it up in cyberspace? Is it at where you are? Is it where the client is? And that's a good question. I don't think that that's a settled area. It's something that's going to be continually discussed. Now, in terms of people who are in state but living out of town where you're servicing or practicing, or you have some of the same problems as out of state, knowledge of what the crisis services are, local supports, and so forth, you may not have as much knowledge of where you can go for extra help or send the client. And if you're going to have ongoing contact with someone in another area, it's probably important to establish main resource guide for the area the client's in. And where can they call, or where can you call or email to find out resources? Now, the reporting duties are yours wherever you're practicing. So whatever your duties are, if you're in Minnesota and you're serving someone out of state, you nonetheless, in terms of mandated reports and stuff, are typically going to be following your own rules. And if you're out of town and a client who's in town calls you, again, if you're licensed in Minnesota, you would be following Minnesota rules. Somebody asked the question, will the slides be available after training? And the answer is yes. Now, some substance abuse programs locally here and in many parts of the United States, at least, are still doing face-to-face practice. That's been helpful to me because when I'm evaluating, I had a social worker sent to me for evaluation. I need to do some testing, and we're not open for that. But I sent them to a substance abuse program to which I consult, which very graciously did all the work. And in this state and in most states and provinces, the issue is going to be the same. It's a safety plan. Reopening is going to involve what are the rules on social distancing. Probably will involve some evaluation of the ventilation situation, disinfecting, and eventually probably some testing. So it's clear that we're entering a domain where whether you've got a small office in your home or you're part of a major institution, you're going to have to be thinking about factors that you never thought about before, like ventilation and distancing. Some of the facilities to which I consult, we're very lucky to have oversized rooms where they now been able to, for a group meeting, move the chairs 6 feet apart and still hold a group. Although one of them, they've occasionally have to put somebody in the middle of the room too, sort of like, looks like the old hot seat. Offering options versus determining what is the best choice for a given client is also going to be here a more challenging issue, because there may be situations where you feel uncomfortable with providing direct service because of your situation or your personal health care vulnerability or so forth. So again, we're going to be balancing our own needs for health and concerns about ourselves and or our own family issues. We have now some terrible struggles occurring in families of first responders, where people are very worried that somebody's going to bring something home. Support groups now are mostly virtual, it appears. So a lot of the self-help groups have switched to virtual type groups, and some of them seem to be running quite well. Now, pandemic-related issues, increase in family tension, I'd referenced earlier, problems with living arrangements. We've also had situations where a family member who's a first responder has been asked to find different living arrangements in a happy family, but one where there's just a fear about something being brought home. Perhaps another family member is high risk medically. And there's great difficulty in visiting family and friends. Obviously, family supports have been stretched, and some families are better able to figure ways through that than others. Obviously, there are challenges to support groups in that you don't have the face-to-face. But the struggle over precautions and safety issues is a real challenge. And let me give you a case example of an ethical dilemma. A counselor was working with an adolescent, still technically, it was late adolescent, 17 years old, less than a year from being an adult. But that means that the parents have access to the records if they ask, except in a substance abuse program. And it also means that there's a greater sense of the possibility that you need to consult with the parents under certain circumstances. What happens when you know that the adolescent is lying to the parents about what they do when they leave the house? They're actually going out and using drugs with friends, sharing pipes, and doing all kinds of dangerous things. If you're talking about the ability to acquire the virus, parents have absolutely no idea that's going on, and are actually, where there are members of the household that are high risk, where did they become ill? How does this change your duty in terms of the privacy or the degree to which you're going to need to be more aggressive with the young person you're working with? It's certainly a heightened area of concern and challenge. Now, the Black Lives Matter and similar social justice movements, as an increasing an awareness of racial issues and greater likelihood they will arrive in any counseling situation. There are certainly questions being asked and people being challenged in a fashion that they've not been challenged before, where people were more alert and more aware and also more willing and able to speak up and say, this has been concerning me. How do you feel about it? Where are you at? Now, there's also a greater awareness and sensitivity to items posted on social media. We got people posting things years ago in a high school thing or so forth that come up. And right now, things can go viral very easily. So again, people that make incautious jokes or are careless in their mode of expression now may find themselves really struggling to have credibility with certain clients, or maybe with all clients. There's a political polarization that's occurred that's beyond any racial thing, certainly as we saw in the takeover of the buildings, a great range of things. You had anti-Semites, you had all kinds of people against all kinds of stuff, very visible, and a great deal of tension developing around it. Now, using the police for wellness checks or transportation to a hospital has gotten to be a much more complicated discussion, especially in certain communities. If you have communities where there've been bad relationships or terrible events that have occurred, it may totally change the valence of that decision making. It may simply be something where you decide not to do it simply because the risk of doing it is great and you just do not want to inflame the situation. So it's going to change the valence as you compare options. Last but not least, there are health differences and differences in vulnerabilities, as you know, related to culture, race, and a variety of other things. And again, these are becoming more obvious and also more troublesome, and also things you need to be thinking about as people struggle with their decision making and come to you for assistance in doing so. Now, let's take an example of applying some ethical principles to a otherwise issue that's bound by law and case law. If you warn the police or an intended victim of violence, beneficence, well, it's not good for the client to hurt somebody else or commit a crime. That's a positive to intervene. Non-maleficence, however, it could damage your relationship with them. In fact, the original Tarasov case probably took place. Tatiana Tarasov is probably dead because the therapist actually did call the police. And once the police got involved, the guy dropped out of counseling. The killing of Tatiana Tarasov in that famous case occurred many, many months later. Autonomy, it violates the client's autonomy. The client does not want you to call anybody. Is it consistent with your role, what you disclose to the client? Well, that's a question mark. What is it you tell clients about the limits of privacy? Justice, protecting others, obviously gets an ethical plus on that one. But there's always been a moral duty most felt to prevent harm. It's part of the standard of care. What's not talked about is there's emotional liability to the practitioner who may not be able to put this stuff in the past. I have people coming to me to process situations that they felt they did not deal with well months and months ago. States, provinces, countries vary as to whether statutes or case law govern, but bearing in mind that the statutes may be just part of licensure laws. Each profession may be different. Only some states have a statute that covers everybody handling a case. So that's a real challenge. And in Minnesota, we face the question of whether trainees and interns are included since they're not licensed. Again, the laws, unfortunately, give protection in most cases to the person who takes the position that they need to intervene in some fashion, but they are all focused on a narrow type of dangerousness. If you look out there, you will see they talk about an easily identified clear victim. as opposed to I'm going to blow up a building or I'm going to the suburbs to kill rich people. Dangerous clients and the threat of violence are a very real challenge. There are a variety of situations. Most calls I get to consult are not duty to warn, but they're rising threat of violence, and the issue is more how to intervene therapeutically. Last but not least, client stalking or harassment of a service provider, that is generally not confidential. And people who feel handicapped that they cannot call the authorities need to understand that what is confidential has to be part of treatment and necessary for treatment. Unless you're teaching the client how to stalk or harass, that doesn't apply. So if you're being stalked or harassed, and 50% of you at the bare minimum will be during your career, that's a reality. Now, what about web research, Googling? Without little expense, we can do research on clients, but should we? The NASW Code of Ethics actually in August of 2017 became the first code to establish any kind of a limitation or standard, and it required that you obtain consent before conducting an online search for information about clients, unless it's an emergency situation. Although, what's an emergency situation in social work? It's not defined. There are not even examples given. But a decision table or chart to do web research or Googling a client, you ask yourself, what would be the positives of never doing it, having a policy, I never do it? What would be the negatives? What would be the arguments to do it some of the time? What would be the arguments to say I do it all the time? There are pluses and minuses of each one. And I think that the bottom line is that there are all kinds of reasons that one may want, for example, to check on criminal justice background. They might want to check on somebody's actual charges. They might want to check, for example, the sex offender registry. Going around the world lecturing on this, by the way, the one thing that comes up the most is female practitioners checking sex offender registries, looking for the names of any new client. That is the most common thing I've seen anywhere in the world. And so again, there's that kind of safety. Now, let me raise one other issue, and that's the question of who's a client, because several other things are going to flow from it. First of all, the definition of a client is very broad and includes even brief contacts. The reality is most licensure laws don't differentiate between psychotherapy clients or counseling clients versus clients of financial services or housing services or other things. Any follow-up can continue the relationship. So if there's anything that says 2 years must pass after the relationship ends, remember that if you have a follow-up contact, the clock just got reset. Termination is not defined very well anywhere, but generally speaking, it has to do with some verbal declaration that in fact, sorry about that, some declaration that there was in fact a decision to stop service and what are the situations. But I want to caution all of you, an ethical duty is to limit care. And if you truly believe what you're doing is not helping or is hurting, it's your ethical duty to terminate. That's the same as it's your ethical duty to decide who to help and who not to help. Relationships with former clients and patients is a whole different area of complexity. I would just note that the standards are predominantly relate to having sex with a former client. They don't tend to focus on much else. And that's unfortunate because there are a great many issues as to when a client is a former client, what kind of connection. Now, what about this whole thing of internet posts? We don't have empirical evidence or predictions based on posts. Preliminary data suggests that posts in general do not predict anything. In general, it provides a basis for discussion, inquiry, and assessment, not a report. Someone can talk violence on the internet and not commit it. Someone can talk love and peace and commit violence. So Right now, the bottom line is not just looking backwards, but the bottom line is if you see something that worries you, talk to the client about it. If somebody calls you and said, I just discovered on my kid's Facebook page, he wrote the following, it's a basis for talk, not reporting. I would recommend to everybody Susan Claybold's book, A Mother's Reckoning. She is the mother of Dylan, one of the Columbine shooters. She spent the next years probing what the heck happened and why the family didn't see anything like this coming. As a teaser, I would tell you that the week before Columbine, her son Dylan had, in fact, been gone to a senior prom after she pushed him to get a date, came back and said he had a great time, thanked her for doing it. And she writes in her diary, and he even danced. And the second thing was his father sitting next to him with arm around the shoulder, gleefully talking about where he would place the furniture on a plot of his dorm room. He had gotten into the college of his first choice, Arizona State. That's days before Columbine. So it's a fascinating book, a very courageous book. I had trouble putting it down. Now, remember, we have a dual or multiple relationship principle in professional work, where having a dual relationship, meaning having a personal and a professional relationship, is problematic, but only if there's a risk of exploitation or harm to the client. Dual relationships or multiple relationships are unavoidable in small towns, small ethnic groups, religious groups. I could list again and again and again all the places where all relationships with clients are essentially multiple. The likelihood that you have some other contact with a client is extremely great. Your job is just to provide and be aware of and be responsible for culturally sensitive boundaries. Now, this becomes an issue because when people text instead of phone calls, it's an abbreviated type of message, but it's very easy to go back and forth. It may be the only quick way to reach some people. It's ideal to make, cancel, or change appointments. But the risk is ongoing conversation, and one that is not only recorded, but for which a printed record can be made. Sometimes that little social banter back and forth looks real bad when you print it out and don't have a context. So I cannot emphasize enough the importance of being mindful of limiting text discussions. Now, I understand there are people that do therapy that way and so forth. I'm not challenging that. I'm saying if you do work that way, that's one thing, but just be aware of the risks. Now, cell phones, a potential treasure trove of tools. You can record and share a clip. You can make an instructional clip. Client can even film a demonstration done in the office. All of this stuff, of course, much more easily done face-to-face. The challenge of creating an app or a tool like that are the client puts it on a cell phone, loans their cell phone. There are always risks to client confidentiality, period. It's a challenge. There's a challenge, and at the very least, you need to remind the client that they loan these things out or give access, that whoever looks at them may well stumble upon that little thing. Client's ability to use an app, do they have enough memory and hardware? The sharing of cell phones, clients buying into an app, cultural issues, their technical literacy, the quality of the manual that goes with an app when you're advising or recommending the use of an app, most of which are fairly inexpensive. What do you know about outcome or risks? Cyberguide.org is a key resource in this, but there are hundreds of apps being created every single day, and yet there's little doubt that they're increasingly being used in the provision of service. Now, networking for support has gotten a little bit tricky. We have blogs that people can join that can help them get support on the internet. They provide social support, ways to cope, self-expression, but there's a risk of personal exposure, questions about identity. Is somebody play acting that they're got anorexia, for example, and actually they're a predator looking for a contact? Go to Wikipedia and look up pro-ana blogs. these are aimed at anorexia. It has a nice discussion of the pros and cons. Among the cons, by the way, are the creation of an identity as an anorexic rather than a person struggling with anorexia. And those are the kinds of things that really are problematic. Sorry about that. I jumped ahead here. Pro-MIA blogs are bulimia related. These things are dangerous and hazardous. They also may be helpful. Clients may come in and ask you about it, or you may give them a generic question of, are there any of these you're looking at? I would just caution you that these things can turn evil fairly easily. However, for some people, they've been life-saving. So the question of support versus trigger is an endless challenge. Does somebody going to an app get triggered, or does it help them feel supported because others are struggling with the same thing? Should you Google a client? The emergency room identity issue in a comatose person's easy. And maybe finding out about someone's history or reality check on claims by the client. But checking criminal justice history, screening for sex offenders, and I've understanding custody studies and with adoption, many social workers doing adoption work have indicated they can find relatives that the people that were at hand didn't know about and arrange successful adoptions using that to track people down. Now, how does all this square with the NASW code? Well, you have it as part of the definition of the service. If you serve criminal justice offenders, as a basic rule, you may well already have as part of your consent that you get to do a background check. And again, with the adoption agencies, they may have that as part of the ground rules. So you can always have it be a ground rule, or you can obtain special permission. But just bear in mind that you need to be thinking about having it clear what the rules are so somebody isn't blindsided. Okay, to try to pull this together, in individual practices, in small projects or in large agencies, the challenge is still, what do you need in the way of communications and social media policies? Do you have any? And if so, how are they communicated to clients? Email, texting, web research. What are your rules on that? What is it that you do or expect any staff do, or that your students or trainees do? What interaction on the internet is legitimate, what isn't? This has to do with the rules you set for yourself and your staff, or that are part of your agreements with your clients. In effect, these are the rules of the road. Friending on Facebook's an interesting one, because everybody says don't friend current clients unless it's an agency website on which clients friend each other. However, the reality is that I get contacted now by clients I saw years ago, and I'm normally delighted to hear from them and learn how they're doing. And I'm always reminded of the fact I'm in the behavior change business, and yet to not know how it all turned out, that seems to be awfully short-sighted. One of the most important things I get from former clients is an update on where they're at. And basically, I certainly have former clients who will encounter me socially, but on the internet, it's a little easier. Someone comes across your name and they'll look you up. Again, people don't tend to talk about the former client, but I do think that we need to have those discussions in each practice setting, and it's going to vary depending on what service you deliver. Last but not least, we had office rules about recording devices. Bear in mind that in states like Minnesota, we don't have a privacy law. We have a anti-wiretap law. As long as one of the parties knows it's being recorded, it's lawful. And the question is, we need to talk about us being recorded, not just whether or not we're honest about recording our clients. And when we're dealing with the internet and we're dealing with distant services, You have no way of knowing what's going on. Now, today, the recording devices are such that someone could be sitting in your office and recording you and you wouldn't know. But I do think this is something that's a ground rule that you need to talk about with your clients and need to be thinking about as an issue, no matter where you live and work. In any spot, this ought to be defined. Whether or not you can, as in Minnesota, get away with it. Just bear in mind, it could be you that shows up on a clip on YouTube one night that you didn't know was being made, which shows you saying one thing for 2 minutes as part of a session, which is taken out of context. Very easy to do right now. But having said all that, I appreciate people's participation. I hope everybody fills out the questionnaire. I hope everybody gives feedback. I am going to be staying on and be available for any and all discussion that people want to do. And I'm certainly available, as the second slide has my email address, as well as the walk-in counseling is just walkin.org. But I'm glad to also answer emails and attempt to discuss any of these issues further. But again, it's been a pleasure meeting with you all.
Well, thank you, Gary. It's been a pleasure to have you. On behalf of the Center for Practice Transformation, we'd like to thank you all for joining us on this first Friday of the new year. And we'd like to extend an extra special thanks to our presenter, Gary Schoner, today, who will be sticking around a little bit. Thank you, Gary.
Been a pleasure.
All right. Well, thank you, everyone. Thank you, Gary. That was a lot of information. It was great information. And we still have a bunch of folks here. A couple folks do have their hands up. And what we're going to do, we call this kind of the extended conversation part of our webinar. And Victoria, you were the first to have your hand up. I'm going to go ahead and allow you to speak to Gary here. And we're going to ask that everyone keep your questions kind of brief to brief-ish, just so we can get, a lot of dialogue here. So Victoria, are you there? You're muted. You'll have to unmute yourself, but you should be able to speak.
Always find it's confusing. It's usually I have to play around to be sure I'm unmuted.
Definitely. So Manchella was next. I'm going to go ahead and we'll go to Manchella. Can you unmute yourself? Do you still have a question for Gary? Oh, Victoria doesn't have a question. Okay, no problem. Thank you for confirming.
Oh, as somebody's saying, I don't see a way to unmute.
Oh, okay. If you hit the participants tab in the bottom, the lower taskbar on the Zoom space, if you scroll over like Gary's camera right now, and there should be some options on the bottom that say participants, and then your name should pop up. There's also an unmute next to that, which is actually easier, probably. Thank you, Diane, who says, I missed the first few minutes. However, I really enjoyed the insight and talk about adolescent substance abuse. Thank you. Nope, this training was an hour long. If anyone else has a question they'd like to be put on microphone and speak to Gary directly, please do raise your hand. Yep, if you raise your hand, I can unmute you, Dawn. You have to hit the participants or chat button. I don't see it as host. I don't see it. So it's probably the best ethics training I've attended. Very applicable and in-depth for a short amount of time. I agree, Eliana. Thank you so much.
Hey, Joe.
Yeah.
Just to let you know, we had almost 400 people on YouTube. And so I'm just letting them know, I said, and try to say a little work here, Joe, I asked them to send me their name and email address, and I'm putting those all together in a Word document so they can get the val and post test for their CEU, because they couldn't get into the Zoom. Yeah.
I applied for the 1,000 capacity license again, and they said, yup, and it looks like maybe it wasn't activated. So I'll have to follow up with them for next month. So we know what to look for here. And everyone who is with us on YouTube right now, if you got that link from registering, you're already in my list. If you got the link from registering in Zoom, you're already on the list. If you got it from a coworker and you didn't register, well, then thank you for sending your information to Peter. We'll make sure you're on there either way. Yes, there will be a certificate. Please, I know some folks have written, I want to get back to this real quickly while we're here. I want to be mindful of Gary's time. A couple folks wrote that there was no unmute option. There is not, but if you raise your hand, I will see it and I can unmute you. And that way we just have it, it's more orderly that way. Sarah, you have the floor. If you unmute yourself, you should be able to speak to Gary.
Hi, Gary, can you hear me?
Yes, I can.
Awesome. So I know this is not particularly an ethics question, but it kind of goes along with it. As far as licensed alcohol and drug counselors being subpoenaed for court hearings and needing to disclose documentation, I found it quite. Now I was instructed by my supervisor that we need a signed order from a judge. But for example, a recent situation came up where it was signed by a judicial referee, and again, in different states, I'm guessing there's different titles or different processes. Is there, whether you can answer this or not, is there a good place for people like me in my specific field to be able to get sound advice?
Good question. A number of states do have a Q&A section of the state agency, and certainly you can call the state agency. I will tell you what the answer to the question though is straightforward. You can do it with the client's consent.
Right.
And I always emphasize that because there are many times the clients will consent. Sometimes their lawyers tell them, you damn well better consent. We got to get on with this. So their own attorney may push that. But in terms of a court order, if you don't have a written order, you can show up with the documents in your possession at a hearing and then ask that an order be given.
Okay.
And that ask that, in fact, the person giving the order is familiar with CFR 42 Part 2.
Right.
And because a search warrant can even be executed against a drug or alcohol program if the judge certifies that he or she is familiar with those provisions and is mindful of them in making that decision. Because otherwise a search warrant doesn't work.
Right.
But again, it's complicated because there is one type of search warrant that does work. What needs to happen though, and if I can pontificate on this a little bit, because I've totally failed at a federal level to have any impact on this, they damn well should change CFR 42 to make it consistent with whatever the general standards are in the community. They did that with child abuse reporting in 1987 because child abuse reporting is not permitted by CFR 42 up until then. But the same is true for vulnerable adults act reporting, breaching confidentiality to prevent a suicide, prevent a homicide. And you know, what the state of Minnesota asks you to do is put it in your client release that you do these things. There's no way that would fly in a million years. So, but the solution is, and I don't know if the new administration is going to be willing to take this on. It's time to clean that up. It's absolutely insane.
Yes.
You shouldn't be in the spot you're in the first place. And but no, I believe that and last but not least, remember, your job is to try to be as helpful as you can within the law. And so perhaps the most important thing is to adopt that approach and say, look, I've got this limitation. You need to get me the permission.
Yes.
And I'm glad to help. but,
Right.
and I don't like to delay things, but I'm not going to break the law.
And that's exactly what I was instructed to do. And it was a request via email, and things of course look very official. And I know it was signed by someone within the judicial system, but was not ever signed by a judge. And so I was having to keep saying, I'm sorry, but due to, my restrictions, I cannot respond without a signed order from a judge.
Oh yeah. Well, then you got good advice. I even take it further and say, I send the thing back and say, please get me what is necessary to open these files.
Yes.
So that we don't waste a lot of time going back
Right.
and forth, because
And that's
you're
exactly
wasting my
what-
time.
Yes,
Yeah.
that's exactly what I was thinking. So,
Yeah,
thank you, Gary.
sure.
Thank you, Sarah. Thank you, Gary. There's a couple other questions. If anyone else has a question you would like to speak directly to Gary, as Sarah did here, please raise your hand. In the meantime, Gary, there's a couple questions that came in here. Any thoughts about risks of remote group meetings being viewed by non-group members or being recorded or even posted online?
Well, it's a very great concern. I don't know if there's been a case of posted online, but I certainly know there are cases of people listening in. And a nightmare scenario is you have a battered wife who's getting help for a domestic violence thing, and the batterer is just outside of the view of the camera, right in the same room, threatening, maybe with a weapon. I mean, that's the worst, one of the worst things. But yeah, all kinds of things are possible. Now, the other irony is, however, there are times when talking to people at their home, broadcasting from their home, is very, very interesting, because you get to see something of the background, and you may get a sense, for instance, there's a hell of a lot more chaos than you knew just because of what you hear and see. But yeah, I think there's a very real risk.
Definitely. It's a real concern. Thank you, Gary. Thank you for the question, Florence. Arlene has a question here. In terms of boundaries, should observing the official hours be only allowed to handle cases online?
Observing the official hours, meaning to do the contacting only within,
Yes.
say, printed hours. I think that's very much an organizational decision and a rule book. Let's take an example of a service, dialectic behavior therapy, as done by the traditional Marshall Linehan approach, where you have coaching calls at night outside of regular hours, but there are some limits placed on it, and there's the team meets weekly to talk about what's good boundaries. And in fact, the boundaries sometimes have to get tightened or adjusted, but there is a programmatic allowance for crisis calls, late night calls. So, and you always have, or coaching calls in the case of dialectic behavior therapy, but outside of DBT, what about, do you put on your answering machine or in your contract with a client that they can call you if they're in crisis? Because see, again, the nature of the service, there's some that simply are open late. But we're in an era where the expectation of the younger generations in particular is that you're around the clock, you're available. And cell phones have changed everything. I was in Victoria Station in London, England, and I got a call from a nursing home in Pennsylvania where my 95-year-old uncle resided. I was the contact. He had fallen down and bruised his knee, nothing serious, but by Pennsylvania law, they had to call. They didn't know where I was, and I didn't have any reason to tell them. They thought they were talking to me at a time frame that was 6 hours earlier in Minnesota. And I just said, look, I'm in a very busy place that's noisy. Let me get to a quiet place. It took me about 10 minutes to find a place that was quiet. I went in the men's room and it was noisy. But that kind of crazy, I mean, you think about that as compared to the way things once were, that's a dramatic change in both expectation and even my own behavior. I was glad I got the call, glad I was able to deal with it. Glad I didn't come back to home 3 days later and find a message on an answering machine.
Definitely, definitely. Well, thank you all for your questions. Peter, did any questions come in through YouTube that you're able to share with Gary here quickly?
Okay.
And I'm not in any rush, by the way, so.
All right.
Gary, you've been so generous with your time and talents here. I feel like we're taking advantage of you. Thank you.
Well, this, for me, the participation in things like this is my continuing education. It's questions and discussion from which I learn every single day.
So true.
It just is. And
I just have one question here. I would like advice on how to explain to a client how it is not legally required for a therapist to give access to records and how it may not be helpful to treatment.
oh, okay. It's somebody that doesn't want to give client access to records.
Right.
It's an interesting dilemma these days because the only except if it's a healthcare record, HIPAA allows only an exception where the access might bring about physical harm to the client. It's very, and with HIPAA, the rule with HIPAA is that if HIPAA gives better protection of the client's rights to access, that's what trumps. So technically speaking, any other rule is going to be subordinate to HIPAA on that one. So we have an interesting situation where access to records, first of all, has changed dramatically. There are times now where a client like of the VA can get better access to their records than the professional who created the record can. They can access from home. Professional may have to go to the office. So, and I might add that healthcare records now have been opened dramatically. And in fact, the medical community is generally very pro access. I know I learn of my test results from my GP before he does. And I get a chance to look at all that stuff almost right away. And I've begun to take that for granted. That's so different from the tradition we've had, which is clients don't look at records and they have to kick and scream to gain access or bring a lawyer, and that we try to keep them away. In all of healthcare, that's not the case. In counseling, the challenge we have is that they have the access legally. So, and I think the other challenge we have, if you're dealing with someone who thinks that way, even if they don't know what the law is, they wonder why, if I can get my doctor's records, can't I get yours? Why can't I see them? I do believe that, in all honesty, the reality is that the records, more and more people have to be trained as to writing the records in a fashion which allows the average person to understand something. Even though there are certainly times when, if you map all that stuff out, you can have an explosion, but you also these days can have an explosion if you don't give access. So I think that's the problem with explaining it. You could explain why you would like them not to look at them, but not why you can deny access. You can't deny access as a practical matter. But you could say that the records are written for your benefit. You guys could waste a ton of time with you explaining something you wrote in a record, which isn't meant to guide them, it's meant to guide you. And it would be a waste of time and a distraction that if they have questions or concerns, they need to ask them directly and you need to answer directly. And that's the relationship needs to take place in the present, directly face to face between us or ear to ear. And that's the approach I would take. I would essentially try to discourage them from doing something that's inherently distracting to them and is not going to help you deliver care.
Thank you, Gary. Thank you. Great question. Thank you for submitting that in through YouTube, Peter. Thank you for sharing that. Here's one, Gary, that came in through the Q&A from Anonymous. How would you begin to have a conversation with someone you know is looking for information about a client on social media without their consent because of a safety concern prior to a first meeting? What might you have them, the professional, consider in doing this?
Okay. The professional becomes aware that somebody is hunting down information on a client, trying to get information sub rosa, not legitimately. That's the question. I think there are several issues. One is whether you inform the client of that or raise the question to the client. Probability is if you suspect it, you should bring it to the client's attention. The risk is, of course, that you can help terrorize the client, but since there's a realistic risk in that area, it's probably good to let them know what's going on. And also that your response to it is to be alert to it and say, that ain't going to work. So that might prove reassuring, but there's always a worry about carrying out the harassment of somebody or the terrorization of somebody by filling them in on it. I give you a simple example. A woman came into a counseling center, and this is a Minnesota case, and made a serious threat that she was going to harm members of a certain family. So the person talked to the supervisor briefly, decided this is clearly a duty warrant. They called the family and said that Susan Jones, who we had no prior contact with, just came in for a first session, has threatened your lives. The family said, who in the hell is Susan Jones? We've never heard of her. They had no idea what it pertained to. So next thing you knew, they called the police, who couldn't do anything. They left their house. They went into hiding. They did all kinds of stuff. They were terrorized by having gotten that call. And so there's a delicate balance sometimes is what you present, but even things like duty to warn are not so clear cut. I realized at the time that if you really hated somebody, the best thing you could do is go in and tell some mental health professional you're going to harm the person and let the professional do the rest for you. But I think as a general rule, most scenarios I can think of, I would be alerting the client to it, but also trying to help them look at realistic risk and dealing with it. And also whether or not there were any laws that might be broken. Harassment is in fact against the law in all Minnesota counties and in many parts of North America. So there may well be a legal issue in terms of reporting to police or others to attempt to get intervention. People just don't realize the degree to which some of these things are not legal, and that this harassment can in fact result in legal action. It can be far short of a terroristic threat to be actionable.
Thank you, Gary. Thank you, Anonymous. Great question. And Gary, you have time for one more question?
Oh, certainly.
You go here. Ann asks, do you think a therapist could be held liable in a situation where the client was unable to ensure their own privacy via telehealth, and this resulted in some legal issues, such as an issue around DV?
Well, the answer to that is the what would be the standard of care in the precise circumstance? And so I would say, lay out the circumstance. And then I would say, is there a standard of care? As an expert witness, I would say the standard of care in that setting would be to caution the person about the issue of people being able to overhear, caution the person that you're well aware that they may be under threat or not able to talk freely, caution the person that if they can, they should go to a place of safety to talk, help the person brainstorm options or to be thinking about options for other places they could go to be safe or even to carry on a counseling session. There are times, for example, when the suggestion of having somebody, this is interesting because you have somebody that goes outside to smoke cigarettes, say, okay, you go take a smoking break, only you go to your car and make a call, don't smoke. But helping, raising the issue and helping someone brainstorm, in the end, you cannot, in effect, control their world or their life. You can only discuss with them options. And there are situations for which there are no good options. And so then the question becomes, would you rather go ahead and talk? The problem here is it's usually, the decision is not how to do it, but the decision is whether to do it at all. So the client obviously has the option of going somewhere to a shelter, assuming they have access to a transportation. But there are people without resources, no question. And all you can say is, we've discussed the dangers, the issues. You'll have to make your own choices. You can't magically change the situation. And again, there are some situations we've seen where having the police come in to intervene or something is not a very safe option. That's, place where more police officers get killed than any other part of their duty.
Well, thank you for the question, Deidre, and thank you, Gary. That was a great answer. Thank you all on YouTube. I'd like to thank my friend and colleague, Peter Dimmick, for helping us set this up. Speaking to Gary, managing YouTube. Couldn't do it without you, buddy. And Gary, thanks again. It's been an absolute pleasure meeting with you and working with you here this week and hearing you today. Hopefully, we can discuss a part 2 someday.
Sounds good.
Great.
I'm certainly be pleased to do it.
Yeah, thanks very much, Gary. Very good. Lots of good comments on YouTube as well regarding your presentation and how helpful it was and useful. So I'm sure, and we'll give you a summary of evaluations when it's all said and done.
Great, really appreciate it. Again, thanks for the effort you're both making to have this program. I mean, it's a terrific thing to have a way to get access to some free continuing education. As we know, it's difficult times. You can't just go to your state conference and get those hours.
So important. We love being a resource and folks, thank you so much for hanging out. You know how to get a hold of me here if you have any questions. Gary, Peter, everyone, have a safe and happy new year moving forward.
Real good. Take care.